Hey all, this is criminal defense attorney Ryan Pacyga, and today I thought I'd tell you a little bit more about Minnesota's statute involving what's called threats of violence. It used to be called terroristic threats, but they changed the name several years ago, probably in an effort to help clarify for potential employers or other agencies that it's not really a terrorism sort of such a situation, but rather a threat to conduct some sort of violence. So Minnesota's threats of violence statute can be found at Minnesota Statute 609.713. And there are actually what are called three different subdivisions or types of threats of violence that are made criminal under Minnesota law. The first and perhaps the most common form of that is threatened violence intent to terrorize. And that means just whoever directly or indirectly threatens someone to commit a crime of violence with the purpose to terrorize another or to cause evacuation of a building or something, or in reckless disregard of the risk of causing such terror is guilty of a felony, which can carry a maximum sentence of 5 years in prison and or a $10,000 fine. The second part of that, subdivision 2, indicates communications to terrorize, and that means someone who tries to communicate with someone with a purpose to terrorize another, or in a reckless disregard of the risk of causing such terror, that they have explosives or an explosive device or any other sort of what's called incendiary device, such as saying I've got a bomb here or something like that, whether or not you indeed do have a bomb, so even a fake bomb threat. That's also a felony, but that carries a 3-year maximum prison sentence. And then we have display of what's called a replica firearm or a BB gun. And if you display, exhibit, brandish, or otherwise use a replica firearm in a threatening manner, then again you can be sentenced to a felony, which in that particular case also carries, in that case, a maximum of 1 year and a day, which is still a felony, or a $3,000 fine. And so those things are all defined. Those are the three broad categories of threats of violence in Minnesota. I'm seeing an uptick in these charges lately here in Minnesota, so I thought I could educate people about them. And then what I'll do is probably make a video for each one breaking down the different elements of those crimes. And I'll give you an example. Under the first one, threatened violence intent to terrorize. If you say to somebody, I'm going to kill you, and that's a threat, like you're in the middle of a domestic argument, right? Nobody's hitting anybody or anything, but they're arguing. It gets pretty heated, and you say to someone, I'm going to kill you, or I'm going to effing kill you, or something like that. And if you're saying that with an intent to scare them, and you know it, even if you don't really mean in your heart that you're going to kill them, but you're saying it out of anger and you really mean it, and the other person legitimately feels threatened by that, that is a threat of violence, and you can be charged, and you will be charged with a felony. Now, whether or not you ultimately have to plead guilty to that or are found guilty of that is another question for later, but that's a very common type of threats of violence in an intent to terrorize situation under subdivision 1. There is a defense called transient threats, and that means something like, for example, if you say to a friend, if you drink that last Coke of mine out of the refrigerator, I'm going to kill you. Okay, people generally know you don't really mean you're going to kill someone there, and you're not even saying it out of anger. It's just like, oh my God, I'll kill you if you do that again. That's not a threat of violence. That's not meant to be that way. And in fact, there's the defense of transient anger is even better than that. I can make another video on that later. But these threats of violence cases are serious because if you pick up a conviction for that, a lot of employers are going to see that, not only see that it's a felony conviction, but also see when they see threats and violence intent to terrorize, a lot of human resources departments are going to say, we can't hire a person with that on their record. It can also cause sometimes some problems with child protective services, with other things that you want to do, like maybe coach your kids' sports sometime, volunteer for Boy Scouts or Girl Scouts, volunteer at a kid's school if they need some chaperones for some things or other things like that. So it's something you want to watch out for. Again, just because you're charged with it doesn't mean you need to be convicted of it. If you have a good defense lawyer and some things happen right in your case, you may be able to avoid that type of conviction on your record. But it is a serious thing, that you have to deal with, because if you try to go it alone, you can end up in, number one, with a conviction that could hurt your record, and second, you could end up doing some jail time or perhaps even prison time if you have enough criminal history points. So if you have more questions, I'm criminal defense attorney Ryan Pacyga. You can reach me at arrestedmn.com, or you can call me at 612-339-5844.